You're listening to the Valley Current.
It's a good example of how he didn't even want to talk about who's going to sign it. I guess he would have left it open. Like, who knows who's going to sign it? It would have been like somebody else, not me, is going to sign it because I'm without electricity today.
Did somebody sign it? Did somebody actually?
Yeah, they sent it to the CFO in Florida, and he just pushes paper all day long. You probably didn't even read it. He probably just said, "Okay, where do I sign? I'll sign. Fine." I mean, he's a retired lawyer. I guess he's got a little bit of financial background, and he's had this job for years, and it makes money. It's profitable. It's just, it's a cash cow, probably. I understand that business is way up, and the course of the pandemic was like the best thing that ever happened to that business. So it's a good example of how a client really can't be delighted by circumstances that to some degree are out of our control. We don't control trial dates. We don't control whether you get a courthouse or not, who you get as a judge, a million different things. So.
Well, the other thing is I think at some point he was targeting right?
Yeah.
And so unless he would have been upset even at that number, I mean, come on. So he paid a little bit over 10% more than his target number. I mean, come on. This is the real world,
Right, but it's more like he's thinking he could have gotten a deal a year ago for $1 million from that original mediator who had a heart attack or stroke in the middle of it. Like, this is just many bad things happen in the course of a case. You can't even imagine explaining to a client that how many bad things happen in the course of a case, right? There's just a lot of bad things that played out. But in his head, that mediator said, I think we can get you a deal at it. And, he probably...
Yeah, he didn't want it. And so,
He thought he should pay zero at that point. He was not willing to pay. Like, the lesson is sometimes $1 million is a cheap settlement.
Well, that was his bad. That wasn't anybody else's problem.
Well, he would say the mediation terminated abnormally because the guy gave the data. Like, if you look at this as like Keystone Cops kind of thing, the guy has a stroke, the thing terminates abnormally. He gives the data to both judges. Both judges get exposed to it. Both judges seem to turn against us. He sees kind of a causation there. Whether it really was or not, I don't know. But the point is, it's like a catastrophe of events that he said he thinks cost him probably, or cost his company kind of and the background on this that a lot of people sort of shrug their shoulders about is normally executives don't take things so personally. Normally it's like, it's shareholder money, right? It's sort of like monopoly money, shareholders are going to pay for it, right? Even when the executives screw up, shareholders pay for it. But this company doesn't have that many shareholders, and he's one of them. And so he does take it personally. It is kind of like his money. Like, in his head, it's not really funny money like some executives, like General Electric, say, would treat it as sort of funny money, I mean, they certainly fight hard, but when push comes to shove, they just say, well, that's what happened. We were forced by the judge to settle, so we settled. Thank you very much, and we're done. And then they forget about it.
Well, you can't have scorched earth litigation on a shoestring budget. And that's something that he just doesn't understand. I mean, every time he comes up with an idea that we have to follow up on and it doesn't pan out, that costs money. I mean,
right.
And he does that all the time, constantly.
Right. So I wanted to cover a couple of educational things to get back to sort of the educational meeting idea on Wednesdays. I know sometimes we do it on Mondays too. And it leverages off of a bit of what we saw yesterday, which is clients are getting more and more sensitive to their legal spend. And in litigation, it's very hard to budget legal spend. More and more clients want budgets and want to believe that budgets are essentially like caps. A budget is not really a ceiling or a cap. It's like a good faith estimate. What is it going to cost? Well, if we assume 24 months of litigation and 3 people, and you can do some math and you can put it into a algebra and say, okay, it's X plus Y plus Z, and you get a number, then you could put a range on it. And then you could talk about crazy, nutty stuff that happens. Like, well, we had a chance to go to trial last year. That's one budget. We had a chance to settle last year. Then the guy has a heart attack or a stroke. That's another budget. Then the judges get the data, and the data maybe corrupts them. I don't know if that's true or not. That becomes another budget for a couple of writs. You can code through all these machinations that is called litigation, and it all tends to be highly uncertain. But what is becoming clear is that clients don't care anymore about how uncertain it is. They want to shift the uncertainty risk to the lawyers. And some law firms are actually accepting some of that risk. I'm not saying we are, but I'm saying there are law firms that will literally quote like a project price and will say, okay, you have this lease case. We're probably not going to listen to a lot of the nonsense that you want to do, file this writ, do this, do that. So forget about all that. This is Kim's point. We're going to defend this case or prosecute this case, or whatever way you want to think about describing this case, for a project fee of blank. And you're going to pay us, a third now, a third when we get the trial date, and a third before we go to trial. And if it settles before we go to trial, we keep the third that we got, the last third. You could argue that's like a success fee, because obviously you must have gotten a good settlement because you took the settlement instead of going forward with the trial. That's just to tell you what the fly on the wall, Joe said, so what's the fly on the wall? Wants a new type of relationship with all of his law firms where the risk gets shifted to the lawyers. And we had a very sort of intelligent conversation about whether that was really doable. Like, let's take the case as an example. I hate to talk about it that way, but it's kind of a case. Like, this guy's got no case. 100 lawyers looking at this case, maybe 5 would say, oh, if I got the right jury and if I got the right judge and, if the moons are all aligned and lots of mistakes were made by the opposing lawyer, I think I could turn it into a winner. But 95 out of 100 people would say, where's the beef? The guy didn't suffer any damages. What happened here? Like, did someone punch him in the nose? He decided to sleep for 3 days and not show up to work. I mean, maybe I'm using hyperbole, but to me, this is the worst example of employment law. Well, I would say, can we fix a fee for that deal? Basically, forget about hourly rates, fix a fee. So the reason I'm giving you this prologue is not because is going away. I think they sort of dislike what's happened with that case, but generally like us as a firm. But more and more law firms are turning to some type of appropriate streamlining. Some people call it legal automation. Some people call it LegalTech. And I want to give an example of it that takes advantage of our discussion on Monday about protective orders, which is, let's give an example of, from the corporate world, the transactional world, which you see all the time, of what do you do when a client says, I want you to tell me whether I should sign a non-disclosure agreement for what might become a supply arrangement with an important supplier. Not a deal yet, just a non-disclosure agreement where we're going to exchange some information. Like, what are the steps that you go through? What are the traditional steps that you go through versus what are the new post-law tech steps that you can go through? Yes, there's actually law tech now that deals with non-disclosure agreements and probably indirectly could even process a stipulated protective order. We'll test it on that in a minute, maybe. But there's actually now people that have gotten venture capital and are using it to create software as a service, so it's in the cloud, that allows you to upload the proposed non-disclosure agreement to their site. And then in about 5 minutes, it essentially spits out an analysis of that non-disclosure agreement. Now, most of us, I think Joe and I for sure, maybe Kim, remember when Lexis and Westlaw was like newfangled research, not paper. When I grew up, when I went to law school, when I was a young man, we used to have these things called books, and they were these paper-bound things that had like 2 covers, and there were like a lot of them. And, if you look at what they look like, because there's some people like books, what's that? See those things behind my picture? Those are books. And in those books, there are published federal cases. In fact, that was a law library that we used to have at 401 Florence in the large conference room on bookshelves, many bookshelves, that had the entire federal reporting system, including bookshelves that were out in the hall. And then, of course, we didn't have any more room. And, these books kept proliferating, and you paid a subscription, which was pretty expensive, to buy these paper-bound books. Now, you might say, for those of you who are fresh and don't know this, how the hell do you find the case inside of a book? Do you just start pulling books off the shelf? No, there were actually tools, non-computerized tools, paper-based tools called key index tools. Joe, do you remember this? The West Keys?
Yeah, there were other books. You went to the other books.
You went to the other books. You went to the other books. And these books were like, this was what it meant to be a lawyer. You had to have a law library. In fact, there were firms that used to still have people called librarians. Now they're called library scientists. They used to be called librarians. And they literally would help you with, well, I'll help you find this book, or the book is missing from the shelf, or the worst case, if you were in law school and the other law students were being SOBs, they'd razor the case you needed out of the book. And then the case was missing because they were too friggin' lazy to copy the case. Do you remember that, Joe? That must have happened to you.
What slow law school did you go to? I mean, my God.
It happened.
People couldn't.
It happened.
Really?
It happened in law. It happened even in law libraries. When you visit a law library, you'd see cases, famous cases that people were always reading, and someone was too lazy to make the photocopy because you have to sit there with the book on the machine. So this is all background to now, of course, we have Westlaw and Lexis. That was like a major innovation to imagine you can search and not have the books anymore and get printed copies of the cases and read the cases and so on. But now it's getting to the point where the automation is playing in a direction of you upload stuff that then does a bit of an analysis. And what's coming eventually will be, and that analysis will spit back some of the relevant statutes and cases that you may want or you should read before you decide what to do it. So I'm going to give an example. I'm going to use an example. Hopefully it'll come up. So we have a client, we have a little tiny client called stands for. This guy started this business. His name is what's his last name? He's German. He said, I'm going to retire in 5 years. And therefore this company we're going to do something that's 5 years out. So I'm going to call it 10. It's not available. So we won't, right? So he has a potential deal with this company called, right? So here's the non-disclosure agreement. This is actually a pretty plain vanilla non-disclosure agreement once it comes on the screen here. So Labs actually sent him this form, not signed, this form. Sometimes they're called non-disclosure agreements. Sometimes they're called confidentiality agreements. I've even seen them called disclosure agreements without the non in it, to sort of say, well, these are the conditions under which we're disclosing. That seems like a mistake to call it a disclosure agreement. And I've even seen some that are called non-confidentiality agreements. That is, that everything you provide is non-confidential except if we specially market. So this one's called non-disclosure, and you'll see it's kind of a form, and it's the typewriting is not necessarily like formatted in some beautiful ways. You sometimes see people do this, and once you get over 3 pages, I think most clients will be like, you read it. Like, I'm not going to read it. And this is like 4 or 5 pages. It goes on, right? So this is like the bread and butter of a lot of corporate departments, right? So this guy does sign it, but he doesn't fill in the stuff at the top, right? He does sign it, but he doesn't fill in the dates or any of the stuff that's at the top. Does he have the parties' names even in it? Let's look at this. Yeah, he just has a blank for the interested party, right? So here's point 1. He signs this agreement and he sends his business plan over with it, like his company slide deck. Does this NDA protect that company slide deck? It's not signed yet. It doesn't even have the name of the party in it. Question number 1, he signs it. Is there an agreement? Is there some sort of implied agreement that, hey, I'm disclosing my company slide deck because I've signed this under Delaware law, by the way, right? Is there non-disclosure? Is there now protection to that slide deck that's marked confidential? Mr. President of Austin, Texas, signed this. What do you think?
Well, wait a minute. Who sent it? Did Zap send it, or somebody else send it?
Send their company slide deck, call it 25 slides about what we do. That's so great. There's some confidential financial data on 2 or 3 slides. Most of it is marketing.
Who did they send it to?
They sent it to the president of Tech.
Okay, but whose NDA was this?
Basically, this guy met somewhere, generally said, hey, we're doing some interesting stuff in area X. This guy said, we're doing some interesting stuff in area Y. Area X is nighttime, night goggle vision, ability to see at night. Think of, the future glasses that you wear at night will enable you, without any headlights in them, to enable you to see into the dark. That's the future. That's what working on. They've actually got a prototype of that. It's a really interesting technology. I
don't think there's a contract.
There's not a contract yet, right?
No. Nope.
There's an offer. This is Contracts 101. There's an offer, and there's kind of a suggestion that I'm trusting you, and I'm trusting that you're going to do the right thing. There's like an integrity test here. There's like an ethics exam kind of thing. This is step 1 of whether we're going to get into some bigger relationship. I'm going to see if you're trustworthy. Here's my standard agreement. Here's my deck. There is some confidential information in it. It's marked. I don't think the deck itself is marked confidential, but I think the couple of pages in the deck are marked confidential. So the client says, I don't know, should I sign this? It's more pages than I want to read. Standard, simple kind of requests that law firms get every day of the week. So there's a company that literally decided to try to automate this process. So inside lawyers and outside lawyers would be able to upload their document into that tool and see what that tool does with the document. So I'm going to download this document and show you in sort of live performance, because this is where the future to some degree is going. Just like the future for Joe, me, and Kim at the time was, hey, forget about books. You don't need books. You don't need to spend a fortune for books. Darrell Nelson, of course, you'll appreciate, Darrell Nelson was, we have to have a set of books. We can't practice law without a set of books. I said, Darrell, I think books are going away. Why would we want to sign a contract for $150,000 for a federal library where we pay them forever on a monthly basis? She was like, no, we can't possibly practice law without a set of books. And then it's like, what set of books? Federal, state, both? I mean, you could spend a small fortune, right? So let me see if I could bring up very quickly. So are there questions so far about this? Because let me see if I can bring up this tool. Might take me a second to find the tab that it's on. Any questions about what I'm pointing to at this point? We got a standard non-disclosure agreement. We got a request from the client to please analyze this non-disclosure agreement. Of course, they would like that. They would like that analysis like instantaneously, right?
I have a question, Jack.
Yeah.
Is our client going to be providing the other side with their confidential information?
Yeah, I think that generally this is headed towards either some sort of supply agreement or some sort of new joint innovation. That's a good question to ask, right? Because you have to decide. And I just want to show people sort of like how these websites, because some people are arguing these websites are almost practicing law. So the website I'm sending here is called NDA, like non-disclosure agreement, NDA, Lynn, because I guess it's a woman by the name of Lynn, Lynn. They came up with this. So if you go to NDA Lynn, you would see it literally says, I mean, there's whoever did this site, they're kind of smart marketers. They literally said, should you sign that document? Now, if there was a legal ethicist here like John Steele from, I guess he's on his own now, but he was at Fenwick as sort of the inside ethics counsel, he'd say that sounds like they're giving legal advice. They're going to answer that question. Should you sign that document? That sounds like what you would ask a lawyer. What a client would ask a lawyer in an attorney-client relationship. That sounds like the practice of law. What comment do you have on that, Joe? Should you sign that document? That's the opening screen. That literally, if you type ndalin.com, that's the opening screen. You'll see.
It's got to be legal advice. I mean, I suppose the only thing we'd have to see what Lynn actually advises. I suppose that she may, give a bunch of, well, consider this, consider that, but that still would be legal advice.
Right.
So I think
Right. This is where you're getting this very early stage view of what's the fuzzy line between information protected by the First Amendment, like what might be called in a book or publication, versus some interactive process with Lynn, an AI lawyer bot. I mean, whoever knew that there was some term called lawyer bot who can review your NDA. I'll tell you if it's safe to sign on the dotted line. I mean, that's a pretty aggressive statement. I don't even say that. I don't even say if it's safe to sign on the dotted line.
Well, the other thing is, I mean, does this do more than just take a document and give advice based on that? Because how could you do that without knowing more about the facts?
Right. So Joe is saying, now, how far does Lynn go into the interactive process? So to me, it's actually very little, because she actually says you can upload the document now, or you can tell me more. By the way, she offers like several languages, English. Wow. This was a Netherlands company. Eventually, they're going to have a lot of different languages. So tell me more. We'll go to tell me more. So tell me more. My machine's a little slow. Says, what am I doing here? This is like the background of, it's all free of charge, by the way, because they're building a database. I mean, they're essentially doing machine learning. I'm free of charge, but if you really want me to try to improve, I'll charge you some money. And I've got an IT lawyer named Arnold, who's located in the Netherlands. He's not licensed in the US, but he charges 99 euros to come in and provide his 20 years of experience in evaluating documents. Sounds like offering legal services in California by a non-California lawyer. Arnold, I searched him on calbar.gov. He's not licensed in California. He's not licensed in Florida. He's not licensed in Hawaii. He's not licensed in Oregon. He's not licensed in any of the 50 states. He's in the Netherlands. He's part of the IT team. And this is what you might call a way for them to get some money into his hands for whatever he does, right? So then she asks some questions. She starts with, I have one question. I think there's more than one. Is it just you giving information to the other, or you're getting information? Notice the icons are very Apple-like icons, like Is it you giving information to the person sitting, or is it them giving information to you, or you're both sitting together? It's what Joe just asked. You give information to each other. So we're going to press that button, right? And of course, she has an explanation for this for those who don't really understand what that means. And then if you want, you can press this button that says include extra information to improve the analysis, right? So your country, now here's what's interesting, actually have United States, California, United States, Florida, United States, New York. Did you see that in the pull down? It's got all these other countries as well. So I'm going to click the button, United States, California. By the way, it's actually United States, Delaware that's in this, because you'd have to see the governing law is Delaware. But I'm saying United States, California, because my client's in California. That's where it is. The other company is in Texas, but they don't have a button for Texas. So I'm just going to say California. And that we're negotiating a commercial deal. There's actually other stuff here. Business concepts, software technology. I mean, maybe it's software technology. It's also hardware. Like these boxes don't really, I'm just going to leave it at negotiating a commercial deal because I think that's really the aim. But there actually is sort of more complexity than that. And then what's your business? Is it technology? Is it something else? I mean, I'm just going to leave it at technology. There's internet, IT, there's a bunch of others. So I'll just leave it at technology. That's kind of the defaults, right? And then she says, now let's see that document, right? So I grab this and I pull it, drag and drop into this. And you notice it says, I hereby give permission to Lynn Legal BV, that's a Netherlands entity, to use this document to improve the Lynn AI model. Now let's stop there for a minute. Can I do that? Can I legally do that? Can I just obviously, technically, I just did it, but it's not yet uploaded. I've got the bullet in the chamber. I haven't pulled the trigger. I guess I could delete all this, but can I legally upload that document and forward it to Lynn to help her improve her AI model? That's why she's working for free. That's what all of these companies that are doing AI are doing. They're trying to vacuum as much information up as they can, just like Tesla does with their mapping system and with their autonomous driving system. They're sucking a lot of data back into Tesla's computers to figure out how to improve their AI model. What's the answer to that, Joe or Kim?
Well, the first thing is, if you got it from somebody else, is the mere fact that you're negotiating with that other party confidential, in which case you shouldn't give it to somebody else without their permission.
Well, wouldn't you say, where does it say the document itself is confidential? Like on the first page, confidential, not to be uploaded, not to be disclosed, solely for internal discussions. This document, even after it's signed, is still confidential, right? Then you'd probably say, hey, you're on notice.
Yeah, but I mean, if it's something where you at least have reason to believe that they wouldn't want that published, put out into the public, I mean, I suppose you can say they should have been more upfront about it, but that's at least one possible impediment.
Right.
And then I guess, I mean, if somebody else prepared it, do they have a copyright in it?
Right. No copyright notice on it. That's the other thing they could have done. They could have a copyright notice on the footer. Some lawyers are doing that.
But you don't need that. You don't need a copyright notice to.
Well, you don't need it, but you have to worry about whether not having it results in an innocent infringement defense.
Right? It's like an implied license or something.
Right. I mean, look, the document was given to me. It looks like a standard form, but it's got the guy's signature. I mean, the better thing for Lynn to have said, just to make people feel a little warm and cozy, based upon Lynn Legal BV stripping out all identifying information, all signatures, all dates, all this, all that, and just using the bones of the document, do you grant her or it or them the right to basically improve their data model? That's what these companies are doing. They're trying to strip out identifying information and just use structure and content without any detail. there is a little bit of detail in that it has a party's name in it, right? At least one side's name in it. So I'm going to take the liberty here, at least under fair use and, section whatever, 107 of the Copyright Act, and let Lynn analyze this. And you're going to see what happens here, which is that literally.
Stay tuned for part 2 of this episode of the Valley Current.